So today I was talking with a gentleman who called us about a few debt collector lawsuits that he had, and he had already lost the cases and they were about to start trying to do either garnishment or freezing of his bank account or doing a writ of garnishment of his bank account. And what I did is I had told him some of the options that we've seen from other clients, some of the things that we've been able to help people with, but something that caught my attention and I want to share it with you. I'm trying to bring my notes back up because I think that this is very eye-opening when you hear what's going on in this state. This state happens to be Georgia, where this individual lives at. And now in all states you have an exemption. So let's just say that you got sued, and let's just say that you were like bankrupt and you ended up wanting to file bankruptcy. So this is, one of the things that a lot of people will say is that, well, why don't you just file bankruptcy? That's what they'll tell people in the comments on YouTube and comments on TikTok and Facebook. Just file bankruptcy. Well, this individual, he owns his own home and it's paid off, but he got into financial trouble. He's on retirement income now. So he has no job. It's just retirement income. And he came to us and he was like, I saw you on YouTube and I think you might be able to help me with my decision. And and it was about bankruptcy. And I said, well, we're not attorneys and we don't give advice, legal advice. But what I can do is I could share with you what other clients, what we've helped them with. And it was mainly to avoid bankruptcy and to help them with debt settlement if they didn't qualify for bankruptcy. And some people want to file bankruptcy that, we don't tell people what to do. They just do what they feel is best for them, but we give them the option. And he said, well, I'm going to go speak with a bankruptcy attorney. And for me, I felt that he was, if he decided to file bankruptcy, being retired, has his home, he's going to have a homestead exemption. Basically, he was going to be okay if he filed a Chapter 7 bankruptcy. He's really in that situation. I think the credit card debt was about $30,000. And then, so he called the office back after he spoke with the attorney, and he was not in good spirits because he said that the attorney stated that if he was to do a Chapter 7 bankruptcy, he would could force sell his home. And I was like, how can they force sell the home when you have the homestead exemption? And then I looked at the state of Georgia, and I guess I'm just completely shocked. Maybe the home values in Georgia is a little bit less than it is in other states, but the primary residential exemption for homestead is only $21,500. For a married couple, $43,000. Each spouse can claim $21,500. That means if your house is worth more than $100,000 if sold, and they can pay you and your spouse $43,000, and they can take care of the debt with the remaining amount of money, guess what? In the state of Georgia, your house could be taken if no other action was done, or if you ended up going and getting I'll take that back. If you go to do a Chapter 7 bankruptcy, they could force you into selling your home. Then the other option goes into a Chapter 13, and we were looking at the laws under Chapter 13. And I won't get into too much into the weeds on this, but basically, if going into a Chapter 13 could delay things, but it could make it very difficult for him. He could keep his home, but the repayment plan would need to pay all unsecured creditors at least $107,000 over time in the example that I did here. So this gentleman has some decisions to make. And so just to review before I get into the solutions that we offered him, if you go to see a bankruptcy attorney, you need to ask them, because he spoke with an attorney before, and that attorney didn't tell him that he could actually. That attorney was just trying to push him into Chapter 7. Not to say every attorney, or maybe he would have brought that up later, but you got to ask these attorneys all the questions. You got to make sure you get all of the details, because I'm pretty sure if you own a home and you end up doing a Chapter 7 bankruptcy and the exemptions are not where you thought they should be, you could end up losing your home over some credit card debt. So looking here, in my state of Wisconsin, it's $7,500 per own, so $150,000. I mean, this is very eye-opening. In the state of Illinois, it's only $30,000, $15,000 per owner. So we got to make sure that we have all of our cards on the table and understand the options that are available. So let's talk about what I would do. I always talk about things on, if, for me, I went through it, and I'll tell you my solution. Number one, if you have the credit card debt and it's already a judgment, and there's nothing that you're able to do about it, you can look to see if it was a default judgment. You can get that reopened, and we can help you with that. But let's just say it wasn't a default judgment and they got it. They got you. The next thing that you got to do is you got to arrange some sort of payment program with them to avoid losing your main asset, which is your home. Yes, they will probably put the liens on there, but if you're proactive about it, you can get some stuff worked out and get some payments going. And yes, we do help with doing that also, because you don't want to open yourself up to answering certain questions, especially if it's something about your home to where they could try to do a forced sale. So my suggestion, if you find yourself in a situation you can't get the case reopened, there's no violations with the case, this is just point blank, you are going to have to deal with that judgment, and trying to figure out a situation based on your limited income or based on your income, is to get a payment plan in place to where it could stop the debt collector from going after you further, looking further into your assets and your job or part-time job or whatever, because we just don't want them to get into doing that. And when you're talking to them, make sure, if you decide to do this yourself, that you make sure that you give yourself some type of I don't know how to say it, but some type of room to not get trapped into answering questions that you don't want to answer. But when you're on the phone with them, they're roughly going to ask about your financial situation, and they're going to want to know those answers: rent, how much your mortgage is if you own your home. But that puts that question in there, or that answer to them, own the home. So you got to be very careful. So just, to make sure that you protect yourself if you end up doing the negotiations with them. But they're going to want to know your utilities, estimated groceries. I mean, they really do ask these questions, and it's a good thing if you're where you're caught in a bad place where there's no other options, and they just get to talking about your expenses. That's a good thing, because then you can get to negotiating some sort of payment plan. And sometimes people will be like, well, Steve, I didn't get they don't want to settle for less. They got the judgment. They're saying that they want all of the money. They won't settle for less. With payment arrangements, I can do the payments, but they won't even do a discount or budge. What I suggest is that you can always renegotiate, but you got to get your feet under you to where they're not going and doing the other stuff. Once you get your feet under you, you get some sort of payment plan in action. Then later, maybe you get your tax refund, whatever. Maybe you come into some money, or, something something happens, and you can call them up, send them a letter, whatever you want to, whichever way. Contact us. We can do it for you, and offer them a settlement, to go ahead and just stop paying the payments and just offer to pay them a lump sum that would get them to take a discount on it. So there's always options. I mean, what we do is when we'll listen, and when we're talking to these attorneys, we hear, they're always making their offers, and it's always, what we believe is unreasonable, but that's what they're going to do. They're going to always go high, and then we have to, get that hardship expressed for our client. We do our best to do that without having to disclose any personal information, and it's a little bit easier for us to do that because we're not that individual. We can always say, well, we need to, get with them, and we can get you that answer. And then we strategize on how, what would be the best way to answer the question that they are asking. And some of the times we just really avoid answering it, and we just get right back to negotiating with them. But, that takes a lot of skill and a lot of back and forth. Another thing that I've noticed with some of the people who have contacted us about debt settlement at the credit repair shop, or through summons master, is that they were with these debt settlement companies, and these debt settlement companies were sending emails to these collection lawyers, or sending mail to these collection lawyers. You don't know. You want to get these people on the phone because you want to lock them down. You want to make sure that you can get some sort of communication going so they don't move forward. Because remember, if they ever try to call you in to do a debtor's examination and you don't make that debtor's examination, they can actually put a warrant for your arrest because they say that you are in contempt of court from not coming in with a debtor's examination. But also, with that debtor's examination, if they feel like you're lying with that debtor's examination, the jail stuff is out because you're already compliant, so you're not in contempt. But it can, you can leverage yourself against having a better resolution with dealing with them. So it's always best to get that communication open and try to avoid the debtor's examination because you've got something going. And then also, if you have cases that are kind of working its way through, maybe they sent a garnishment notice or rid of your bank account, like they're notifying you in advance that they're going to be moving forward to do some of that stuff. When you have that communications open, whoever you choose to work with, but if you choose to work with us, we start right away to make sure that if any stuff was started, that we kind of put that on hold, and we get that communication from them that it is on hold. And then if they ever tried to go behind your back or to do something against you, we would have that notification. We would send that straight to the judge, and they could probably perhaps get the whole case thrown out. So, bottom line is there's always going to be some options. Every day we got to learn more because, I didn't even think about it this way with the homestead. So we got to understand our rights. We got to, when it comes to exemptions, we got to understand our exemptions. We got to understand what they can and cannot do when it comes to these debt collection lawsuits, these civil debt summons. We got to understand what we need to do if we find ourselves trapped, and we try to look at some options that are available. That communication is key, but we want to make sure that we don't leverage ourselves by the communication that we have with those debt collection lawyers or their representatives that they put in place to talk about the negotiations. Another thing that comes to mind is that if a debt collection attorney is working for the original creditor or another debt collection firm, you always have the right to, when you're submitting settlement offers, to request that you get something in writing from the actual plaintiff, because they're using these lawyers in between, a lawyer that's in your area. You have a right to ask them to get you information from the plaintiff that is on the lawsuit to say, no, we decline this offer or something, because we've ran into that from time to time where they'll be like, hey, they said no, and these they do give them an amount that they will take as an offer right off the bat because they don't want to have the back and forth with them. But some of the times when you need to go lower, you got to do a lot of work, and then they'll try to say no, they're not going to accept it. And what you have to do is you have to push very hard to get them to get that to that plaintiff and get something in writing that the plaintiff said no. Because some of the times they might just say no just to say no. Something else that comes to mind is if you respond. Now, this is very, very, very important. If you The reason why it's important to respond to your debt collection lawsuit summons, sometimes people will say, well, I'm just going to skip the whole process and not respond. Let me tell you why it's very important to respond. Is because they will see that, number one, you did do something, that you're going to be someone that's proactive. Number two, if you respond appropriately, you're going to get that attorney to start feeling a certain way, because they have to double check that they filed that case properly. Because if they made any mistakes, when you respond the right way, and I'm not talking about a debt validation, you have to respond, fully formatted response to the court to all allegations and a defense to help you win the case. You do that the right way, it's going to get that attorney to understand that they're not dealing with the average individual. And they will feel a certain way personally because the finger is being pointed at them for the job that they did, but also the documentation is going to make them have to get documentation. What I've seen from experience, when you do this the right way, they will sometimes delay out the case, or if you get it to them in time, they're going to contact you before the hearing to try to talk to you about potentially settling the case, and they're going to come with a settlement that's very good because of the work that you did on your response. That's very important. Like, we see that a lot. Some of the times they'll just dismiss the case. They'll just dismiss the case when you respond appropriately. So to close it all out, if you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, what makes us different, so you can see my 8-point validation process, my 2-phase settlement process. If you need help settling debt, you can contact us at thecreditrepairshop.com. Go to the live chat, let us know. We'll ask you some questions, and then if we feel that we're a good fit to help you out, we'll get you started on resolving your debt. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you early in the game, go to summonsmaster.com, where you can get a fully formatted fully formatted debt validation letter, exclusive certified debt validation letter to stop debt collectors in their track. And if you're being sued by a debt collector, you can go to summonsmaster.com, where you get a fully formatted response to every allegation and a defense to help you win your case. That's summonsmaster.com. Links are below this video. Thank you for your time. Subscribe to the channel, post your questions and comments. This is Stephen A. Williams, president and founder of thecreditrepairshop.com and creator and founder of summonsmaster.com.